By this time tomorrow, the Madlanga Commission of Inquiry would have had its first hearing. Let's get analysis now, perspective from Zola Majavu, Chartered Director and Senior Legal Practitioner. Good to have you on the program, sir. So, while we're preparing for the start of the inquiry, at least one political party, the MKP, is aggrieved because its case against its very existence is set to be heard by a court on Thursday. Legally, though, does it matter that 24 hours before that, the Commission will sit for the first time?
Good evening, and good evening to the viewers out there. It doesn't matter. It may well have practical ramifications. The one school of thought may have said the Commission should have awaited the hearing of the matter on Thursday, but the risk with that is that there's no guarantee that an outcome or a ruling will be necessarily delivered on the same day. And that means the Commission is losing further days that are already being lamented. So it makes no legal difference, and I don't see why the Commission should not start.
And is there anything, for example, when you look at the issues that have been cited as to why this commission should not happen? Yesterday, when we were speaking to the spokesperson from the MKP, he was talking about how they don't believe that, well, now retired member of the judiciary should be leading a process that, for example, is likely or is expected to implicate members who are either past or present in the judiciary itself, but also that there's a parliamentary process underway also dealing with the same set of allegations. Is that a convincing argument to give to a court as to why this process should not happen tomorrow?
Out of respect to the MK party and their legal arguments, I, for one, am not convinced that there is merit to those assertions. There may well be arguable points, and they may well persuade the court. But remember, there's also a separation of powers principle. The parliamentary processes must go and run their course. The pseudo-judicial processes must also run their course. And I do not see why one should be dependent on the other or the one should be subordinated to the other. The fact of the matter is this commission was established lawfully so on the authority of the person who is a repository of such power in the form of the president. And the gazetting of the commission as well as the relevant regulations has already come and gone. And all that has to do is for the commission to get underway. There is no interdict currently in place stopping or prohibiting the commission from starting. If anything, this commission is already a couple of weeks out of schedule. So I don't really see the linkage between the two.
And on the commission itself, there's been a lot of talk, especially in the last, I think, week or so, because the spokesperson for the commission, Jeremy Michaels, basically said that the findings of the Madlanga Commission will not be legally binding, but they will carry significant weight. So ultimately, the president will have final say as to what is actioned post the compilation and the issuing of the report. But that significant weight, is it enough weight in law to bring about action? Can it force any sort of action to be taken?
It is not insignificant. Yes, the legal position is very clear that the commission doesn't have binding authority, but it would be very worrisome if the president who set up this commission were to ignore the recommendations or to make light of those recommendations. Yes, legally, at the end of the day, the final decision rests with him, but I cannot imagine that he would, in the face of a matter of such public importance and public interest, would easily ignore the recommendations made by the commission, which has extensive powers, the powers to search and seize, the powers to coerce people to come and participate. So I cannot, in fairness to the president, imagine that he would be so imprudent as to just ignore without good cause those recommendations. But yes, legally, they are not binding, but I cannot imagine that we should minimize the impact and the significance of fact-finding exercise. There are serious matters implicated, and it is about time that as a country we get to the bottom of the truthfulness or otherwise of these allegations.
And ultimately, Mr. Majavu, we've all had our say, haven't we, on who we think are the heroes, the villains in this story, but it comes down to the evidence ultimately over the next few months. That's what is going to determine the actual outcome. Some of that evidence might be handled or heard in camera due to sensitivities around intelligence, etc. I'm curious, though, about the threshold that the inquiry will have to meet in making those decisions, especially when you consider that there's already been so much controversy around who might or might not be shielded. And they would want to not lose, won't they, the sense of credibility, especially among the general population.
I think as a general proposition, there would be nothing wrong in the protection of the volition of those who elect to come forward voluntarily. And we cannot also fool ourselves by minimizing the possibility of intimidation and some form of reprisals. So the commission would be privy to the nature of the information, the sensitivity thereof, and then exercise its discretion in deciding to hear that kind of testimony in camera. It is not unheard of. It has happened before. There is absolutely nothing wrong with that approach. If you don't do it that way, you run the risk of people who would have otherwise come with credible information may simply be dissuaded because people have been killed in the past, and that threat is real. And the commission would have to ensure adequate protection measures, which are not and should not be publicly available. Otherwise, it defeats the very purpose. But at the end of the day, the evidence of those who testify in camera must still be tested. The fact that they're testifying in camera does not mean that they would not be subject to cross-examination.
But can witnesses, as we saw with the Zondo Commission, simply refuse to answer certain questions because they don't want to incriminate themselves? And if so, how much does that hinder the pursuit for truth?
Well, it's unfortunate. That is part of the game. The Constitution ordains the right against self-incrimination. However, if there is an accusation against you and you elect not to rebut it, in all probability, an adverse inference may be drawn against your refusal to so rebut an objective accusation that is leveled against you. But no one can force you to incriminate yourself because the Supreme law of the land says that right is circumscribed and it is ordained. But yes, it may put some hold on the pursuit of truth. But law is not about the truth as we know it. It's about the truth as we are able to prove it. And sometimes the proof thereof is where the difficulty lies. But you are relying on people, some of whom are going to be found wanting. Some of them may be lying, or some of them may make allegations that they cannot substantiate. And the flip side of the coin is that people's integrities may also be dented unlawfully, which is why the commission would do a very careful balancing act to make sure that those who want to testify do so without fear or favor or prejudice. On the other hand, those against whom allegations are made must be given a fair opportunity to confront their accusers, whether in camera or off record. But they have to have an opportunity to test the allegations or the veracity of allegations against them.
Zola
This is how the
Majavu,
rule of law operates.
good to talk to you. Good to have your time this evening. So thank you very much for your time.